Consuelo's father passed away in 2011, predeceasing his remaining parent, mother. From what Consuelo knows, her father has properties but they are not registered in his name but in his mother's name. Consuelo's grandmother passed away only this year. Her grandmother was not able to transfer the title of any property to her heirs. From what Consuelo knows, the house where her grandmother lived was allotted for her father and another property with lessors were also for her father. The property at the back of their house was given to her aunt. Most of the properties of her grandmother were never transferred to her grandmother's children, but they were instructed verbally by their grandmother regarding the properties that each was to take. She wants to know what proper steps they may take in transferring the titles to the properties in their names. If they decide to sell the properties, do so, even if the titles are still registered under her grandmother's name. Consuelo, when your father died, what you and your co-heirs, such as your mother and siblings, should have done was to settle the estate of your father. Since he predeceased his mother, the moment your grandmother passed away, you and your siblings shall inherit by right of representation, effectively stepping into the shoes of your father as your grandmother's heir. What you and your aunties and uncles should do is settle the estate of your grandmother under Section 1, Rule 74 of the Rules of Court, which provides, if the decedent left no debts and the heirs and legatees are all of age or the minors are represented by their judicial guardians, the parties may, without security of administration, divide the estate among themselves as they see fit by means of a public instrument filed in the office of the Register of Deeds. And should they disagree, they may do so in an ordinary action of partition. If there is only one heir or one legatee, he may adjudicate to himself the entire estate by means of an affected affidavit filed in the office of the Register of Deeds. It shall be presumed that the decedent left no debts if no creditor files a petition for letters of administration within 2 years after the death of the decedent. The same procedure should be done for the estate of your father. If all the heirs, after proving that your grandmother has no debts or creditors, wanted to sell the properties and divide the proceeds among the heirs, you may do so, but this will put any buyer on a defensive stance as the properties are registered in the name of a deceased person without them knowing the status of the settlement of the estate. It would thus prove to be quite difficult to dispose of. Be reminded that our opinion is based solely on the information you provided us, and it may change depending on any additional information. You are free to consult a lawyer of your choice regarding your legal concerns. Email us at ptv4newscenter@gmail.com or newscenterptv4@gmail.com. Attorney J.J. Jimeno-Atienza for the Rule of Law.